we want to know, I mean, everyone wants to know, you're going to be able to prove your case. I mean, is this a 90% case or a 10% case? It makes a big difference. Okay, that's what we're looking for first. Second, we're looking for damages. So what, we're going to win. Who cares if you got a better job the very next day? There's no tears in this case. And so even if we win, we're only going to get peanuts. And so damage is a big factor. Sometimes liability can be low, but it's a good case because damages are so high that if you win, it's like lotto time and you get tons of money. Sometimes it's reverse. Liability is very high, damages are low, but it's so easy to get judgment and you're going to win almost for certain that might as well do it. So, but the best one is high liability, high damages. That's what interests an attorney most. Now, third, can you collect on it? Collectability. It does you no good if the employer is going bankrupt, and even if you have the best case in the world, if you can't collect on it, who cares? So we have to evaluate that. The last point is sensitivity. Sensitivity. How sensitive are the things you're raising? I mean, is it something that's going to make the employer shake in their boots? Are they sensitive to it, or are they just going to kind of laugh at you and say, I'll see you in court? So those are factors the employer, the attorney is going to look at to see what kind of case is this. Is it a real good case, or a ho-hum case, or what kind of case is it really? So you might want to keep that in mind. You can kind of evaluate your own case and what situation you might have there. Okay, I'm going to come back to this in a second, but a couple other things that we need to look at on evaluating. Once you evaluate your case, then you've got to decide, where do you go from there? What do you do with this great knowledge? You have more knowledge now than you had a half an hour ago. You got to decide, okay, with this knowledge, what am I going to do with it all? So, and what you do with this knowledge depends upon what your goals are. Now, not everything requires a gigantic fight. Like in this situation, don't fire anyone until you see the whites of their eyes. It's almost like a war between management and the employees. You don't necessarily need to get in the big battle if you understand your rights correctly. Now, what are your goals? Are your goals money? Usually that's what people have a goal to accomplish if they've been terminated or whatever. Do you want to be reinstated to your old position? Sometimes you don't want to get back in that old can of worms and just don't want to get into it again, but some people do. Do you want to improve a settlement package? They've offered you $10,000, you want to improve it to 20 or 30. You want a letter of recommendation, or do you want to change the employer's policies? But not a lot of people want to be a policeman for the world, and they just care about themselves, and so sometimes that doesn't really matter to them. So, but it makes a difference, though. I mean, if you want to be reinstated, your approach with the employer may be totally different than if you just want money, or if you want a letter of recommendation. So you have to first define where do you want to be, and then you decide the appropriate vehicle or method to get you there. So you have to kind of do it backwards to figure out where you want to go, and then I'll tell you how do you want to get there. Okay, so now in talking about the vehicles to get there, or the methods to get there, your options. Well, you can always forget about it. Waive your claim if you decide, well, I don't want it that much, and just go on life and put it behind you and not get stressed out over the whole situation. You can informally negotiate yourself. Talk to the employer and try to do your best to get some more money or try to resolve the situation. Too many people pull their gun first and get in a big war before they even start to talk. I think a lot of employers would do better with more effective communication and talking first and trying to resolve it. But unfortunately, many employees don't know what their rights are. They don't know what those rights are worth, and they don't know what buttons to push to get them. And so that's kind of the problem. The employers don't take you seriously sometimes. So that leads to attorney negotiations that sometimes result. You have to go to an attorney. Some attorneys, advantage is that many attorneys are experienced, they're specialists, they know what they're doing. They can present your case for you in the very best manner. They can brainstorm with you and be very creative in what your rights are and your claims. And the attorney will normally be perceived a little bit stronger than you would be on the other side. They know that you're more serious. Disadvantage is raises the confrontation level a little bit. Attorneys can be expensive if they're on the hour. Sometimes they're on a percentage basis, like it's called a contingent fee basis, where they only get money if they win. They take a percentage of it. So there's lots of different attorney arrangements, and you can negotiate. That's the point there. There's a lot you can do to resolve a case without ever filing a lawsuit. In our firm, most of our settlements come before ever filing a lawsuit, because we feel that you've got to do your homework and present the whole package. If you do a good enough job and give the other a chance to respond, most employers want to resolve it. They don't want to pay their attorney tons of money to fight you in court and have the bad publicity and all that. So you can go a long ways with negotiation. Next one is a lawsuit. Lawsuit is good, is that justice will be done eventually, sometimes. You know, you can never predict a jury, and it might be very costly to get there, and it might take 2 or 3 years to get there. But ultimate justice will be done if that's the method you want. But there are some advantages and disadvantages to that. You do the employer internal grievance procedure, which is a method you can use. A union grievance procedure. You can go to the state agency, which in California is the Department of Fair Employment and Housing, or the federal agency, Equal Opportunity Commission, and they have means set up where they'll investigate your claim and help you, but they have blinders on. They're only looking at one thing, discrimination. They're not looking at breach of contract, blacklisting, or anything else. So that's the advantage of that. They're free. They sometimes take a year or more. What they can do for you is sometimes limited, but they can get you money, and they can address it if you don't want to use the other methods. Okay, on other options, you can go to the state labor commissioner for your non-discrimination claims, such as wage and hour type claims, overtime, or the federal Department of Labor, which is the counterpart to the state. You can go to small claims court, which is sometimes good, but you're limited here in California to $5,000 recovery. And if you win, they can always appeal it to a higher court in which they can have their attorneys present. So it's very inexpensive, it's quick, but if you get anything decent, they'll probably appeal it to a bigger court anyway. So there does have some disadvantages. Unemployment compensation. You can, even if you've been fired, you can still get unemployment if you want. The employer has to show that you're guilty of deliberate misconduct for you not to get your unemployment. So don't think that you don't deserve it, because you do. Social Security has some payment options. Disability, both private and state programs. I talked to a gentleman today that his son had a terrible disease. He was off work for 6 months. He finally decided to file for disability to tap into short-term, long-term disability before they get around to firing him. So he was smart. He's taking advantage of the benefits of the employer before something might happen where he might not qualify for it anymore. But disability is sometimes available. And there's state disability, whether before or after termination. Workers' compensation if you're injured at work. Okay, and this last one is, when should you act? When should you do things? Deadlines. It's commonly called statute of limitations. Normally, it's about a year from the date of the wrongful act. Not from the date of the termination. Now, the termination may be a wrongful act, but if termination is the culmination of a long series of retaliation or discrimination against you, it might be from the first act that you have a deadline. So you've got to be very careful where you're planning from. On a union claim, it might be a matter of days. A month for government employees and labor commissioner claims, and a lot of claims. They've, in California, extended a lot of those to 6 months. 90, 100, 300 days for federal law, depending upon what state you're in. It could be 2 years for breach of oral or implied contract or back wages, 3 years for fraud, overtime, breach of some statutory laws, 4 years for breach of written contract. So the point is, there's a wide variety of statute of limitations deadlines on a lot of these claims, depending upon the nature of your claim. And the lesson is that if you think you have a claim, it's very wise to research it out, figure out really, do you have a claim, and then do something about it. Either forget about it, go on with life, or do something about it. Go to an attorney or go to a state agency or read a book. And otherwise, if you delay, you may be waving goodbye to your rights. So what I'm going to do now is I'm going to get a little bit more specific and talk about a lot of your rights and answer some of your individual questions. But before I do that, I'm going to close off this portion of the program. Now I'm going to get a little bit more specific with you. But the conclusion of any discussion on employee rights, as we've just done right here, as as I mentioned at the beginning, is there's lots of rights out there. You know a little bit more now than you did before, and there's a lot more to learn. There's a lot of rights that you didn't know you had even now unless you really pick it apart. And the good news is there's lots of things to do about those rights, lots of methods, and lots of things that you can do against your employer in dealing with it. And not everything has to be a big, expensive, protracted lawsuit. There's a lot you can do on negotiations. So again, there's more rights you have now than any other time in the history of the world, and the challenge to each one of you is to do something about it. So thanks. I'll be back in just a few minutes, and we'll continue on.